I would first like to acknowledge that this presentation is being recorded on the traditional lands of the Kurrangong Balak people of the Woiwurrung Nation and pay my respect to elders both past, present and future. Mabo claimed that the Miriam indigenous people of the Mer Islands were the traditional landowners of their island and had always owned the islands. In defending this claim, the Queensland government argued that Australia had been seized by occupation, and thus, as soon as England claimed terra nullius, the laws of England became the governing laws of Australia, including the feudal common law rule of tenure, which they argued was defined just as the Crown had universal ownership of all land in England, so the Crown became the owner of all land in the Australian colonies. They further noted that because the courts of a sovereign state cannot challenge the very sovereignty which gives the court power, that even if the courts disagreed that Australia was ever terra nullius, they couldn't overturn tenure on those grounds. But luckily, the courts didn't have to. And that's because Mabo No. 2 didn't turn on whether sovereignty existed. The courts found that terra nullius was false and unacceptable in Australian society. However, this was only part of the question of land ownership that needed to be decided for Mabo. The reasoning of tenure failed because tenure never imparted onto the Crown a right to own all the lands of Australia. The definition adopted by the High Court was that tenure related to the Crown's right to govern over all lands and own the title to the country, but not to own every specific section of land, including land occupied by others. And this is logical, because if the Crown owned all land, an Englishman landlord wanting to rent their property would be subject to some pretty complicated hoops, as they themselves aren't really the owners of their land anyway. So essentially, Mabo found that the sovereign has supreme power to govern, but not supreme ownership of all specific lands. Therefore, the people of the Mer Islands were subjects of the sovereign, but could nonetheless own and tend to their lands as they saw fit. Now, how did the courts use this precedent to decide the Walker case? Walker was arrested for a criminal offence on the lands of the Bandjalung Nation during a protest. He claimed that the Commonwealth of Australia did not have the right to enforce Commonwealth laws upon him on Indigenous lands, and that he was entitled to be tried under Indigenous law. The precedent from Mabo that customary laws of land ownership must be recognised was argued to give rise to a common law right for other customary laws to be respected, including criminal law practices. And this was supported by a passage cited in Mabo, which stated, "Colonists carry with them only so much of the English law as is applicable to their own situation and the condition of an infant colony." The courts took the narrow approach of interpreting this statement, noting that applicable to their own situation included all persons and matters within the territory to which it extends, but not to any other persons and matters. And therefore, it did include Indigenous Australians as persons within an Australian territory. And really, looking back to Margot, this is logical as well, as the courts very precisely never suggested that the Crown had no sovereignty over Indigenous people, only that sovereignty and ownership of specific lands were distinguishable. And so, for really the same reasons as we discussed in Mabo, the Crown had supreme power of governance over its subjects, and so Walker had no right to opt out of sovereign laws. So what does this mean present day? Does Walker limit the scope of Indigenous power to land title only? First, in the Mabo judgment, the judges noted that this case empowers international law, because the International Covenant on Civil and Political Rights was used as a key tool for interpreting existing statutes. Judge Brennan, with whom Mason and McHugh agreed, declared that the opening up of international remedies to individuals pursuant to Australia's accession to the ICCPR brings to bear on the common law the powerful influence of the Covenant and the international standards it imports. Secondly, there has been some debate about whether if Walker were tried today, it would be upheld. And it is my belief that it would not. Recently, in Camino v. Canaan, it was held that the right of Indigenous Australians to be heard in a Koori court is a cultural right enshrined in the Victorian Charter of Human Rights and Responsibilities and the United Nations Declaration on the Rights of Indigenous Peoples. And I think a really important way to bring these cases back to the topics discussed previously in this class is in a context of power relationships. A key principle of law is that all people are equal above the law. And in some ways, Mabo embodies that the law considers all cases thoroughly, no matter how great that power imbalance is. And I think this conversation describes that quite well. When Mabo won the land title case in 92, his lawyer called the phone box on Murray Island to explain the judgment to the people. And the conversation is described by Mabo's attorney as follows. "Hello, Brian Keane-Cohen here. Who's that?" "Do you remember Eddie Mabo's case? That court case about land?" "Yes." "Well, I'm ringing you from that court in Canberra where those top judges are. You know, that High Court?" "Oh, yes." "Well, those judges, they told us their decision just now. Eddie won. You Murray Islanders have won that court case. You own the island under your laws and custom." Screams of what I took to be joy, laughter, yelling. Much discussion in the background. "Hello? Hello, is anyone there?" says I. "Oh, thank you. Thank you, we are very happy. I have to go and tell my mum. Goodbye." "Bye. See ya." Thank you.